This is an appeal in the matter of Great Jackson St Estates Ltd and the Council of the City of Manchester.
Good morning.
Good morning, my lady, my lords.
First of all, let's talk about timetables. So far as we're concerned, this matter is listed for a day and a half, and I imagine that you have divvied up the time between you. But in any event, we ought to tell you that we have read very widely, and so you can assume that we're au fait with a great deal. And so, so far as we can see, in relation to the central points, this shouldn't take so long. Put it that way. Leave it to you.
Thank you, my lady. We had understood that the time had been extended to 2 days, but obviously we will...
No, not so far as we're concerned. It may have been, but we don't know. And in any event, we can't see that it could possibly take 2 days. As I say, we'd be surprised if it took 1.5. So if you would take that into account, we'd better get started.
Very good. As the court knows, I appear with Mr. Gray for the appellant, Great Jackson St Estates, and my learned friend, Mr. Morshead, King's Counsel, and Ms. Tithcott appear for Manchester City Council. The respondent, it's an appeal against decision of the Upper Tribunal dated the 8th of August 2023, with permission granted by Lord Justice Arnold. There are 2 grounds of appeal. The first relates to jurisdiction and the second to discretion, and the Council objects to one aspect of our arguments on the first ground of appeal. But my learned friend and I have agreed, subject to the court, that I should present my arguments, and then my learned friend can take objection to them in his response, and the court can deal with them at the end.
That's 84(1)(c).
Yes. Can I start with section 84, which is in the authorities bundle at tab 2. So as the court will have seen, this gives the upper tribunal power, and it's a power, not an obligation, so there is a discretion as well as the question of whether the tribunal has jurisdiction on the application of any person interested in any freehold land, but by subsection 12 that also applies to long leases, affected by any restriction arising under covenant or otherwise as to the user thereof or the building thereon, by order wholly or partially to discharge or modify any such restriction on being satisfied of one of 4 grounds. And here the land is affected by restrictions, some of which are absolute in form and some of which are qualified in the sense of council's consent can't be unreasonably withheld. The most important covenant and the fundamental obstacle is the user covenant, which says that the council, that the land is only to be used for commercial purposes unless the council consents otherwise. And there is no proviso that that consent may not be unreasonably withheld. The 4 grounds are then set out in the tribunal.
So in fact, that provides a quite a high degree of control in the council over the use of the land.
Yes. There are 4 grounds. 3 of them were relied on in the tribunal. We're only appealing on ground AA.
Yes.
That in a case falling within subsection 1A below, the continued existence thereof would impede some reasonable user of the land for public or private purposes, or, as the case may be, would unless modified so impede such user. The tribunal held that our proposed user was reasonable and that the covenants impeded that user. By the respondent's notice, the council says the tribunal was wrong on both those points. The council says that a user which isn't practicable isn't reasonable, and a covenant which prohibits an impracticable user doesn't impede it. I will deal with those points in my reply rather than in opening. We then turn on to section 1A on the next page. Subsection 1AA above authorises the discharge or modification of a restriction by reference to its impeding some reasonable user of land, in any case in which the upper tribunal is satisfied that the restriction in impeding that user however, does not secure to persons entitled to the benefit of it any practical benefits of substantial value or advantage to them, or is contrary to the public interest, and that money will be an adequate compensation for the loss or disadvantage, if any, which any such person will suffer from the discharge or modification. There are two limbs, A and B. A is generally referred to as the limited benefit limb and B as the public interest limb. In one sense, every covenant that restricts the use of land confers a practical benefit on the covenantee because it gives them control over the land. It enables them to stop things from happening on the land. But that cannot be what is meant by practical benefit here. Otherwise, every covenant would confer a practical benefit. Rather, we submit that subsection 1a requires the tribunal to consider if there is a practical benefit secured by preventing the specific reasonable user in question from being implemented. And we say that subsection 1a is only concerned with practical benefits that result from the covenant remaining unmodified or undischarged and being complied with, and the reasonable user not being put into effect. It's not concerned with benefits that can only be realised if the covenant is modified or discharged and the reasonable user is put into effect. And even if that is wrong, a practical benefit that can only be realised if covenants in a lease are released and replaced by a new and different set of covenants in a different lease is not a practical benefit for the purposes of the subsection. The subsection says that money must be an adequate compensation for the loss or disadvantage of any which a person will suffer from the discharge. The tribunal didn't address that issue, but by the respondent's notice, the council say that even if everything else is found in our favour, the appeal should be dismissed because money wouldn't be an adequate compensation for the loss or disadvantage it claims it will suffer. And again, I'll deal with that in my reply. Mr. Dre will deal with that aspect of the argument. Moving on to subsection 1b, in determining whether a case is one falling within subsection 1a above, and in determining whether in any such case or otherwise a restriction ought to be discharged or modified, the upper tribunal shall take into account the development plan and any declared or ascertainable pattern for the grant or refusal of planning permissions in the relevant areas, as well as the period at which and context in which the restriction was created or imposed and any other material circumstances. So that makes it clear that there is to be a focus on planning considerations in deciding whether the requirements of subsection 1a are satisfied, and also in the exercise of the tribunal's discretion. In the present case, the development was in accordance with the development plan, and the council had resolved to grant planning permission for it prior to the hearing before the tribunal. And since the hearing, planning permission has been granted. And then subsection 1c says it's hereby...
Sorry, planning permission has been granted. There was an issue about section 106 agreement, and I think it was said that no one doubted that it would be resolved.
It has been resolved and it has been signed in November last year.
Thank you.
Subsection 1c says it's declared that the power conferred by this section to modify a restriction includes power to add such further provisions restricting the user of or the building of the land affected as appear to the upper tribunal to be reasonable in view of the relaxation of the existing provisions and as may be accepted by the applicant. And the upper tribunal may accordingly refuse to modify a restriction without some such addition. We rely on subsection 1c to support our argument, our first argument, on the interpretation of subsection 1a. And the council says we can't do that because we didn't refer to it in the hearing before the tribunal. Under subsection 1c, new restrictions have to be accepted by the applicant. In one case, it was argued that this meant they couldn't be proposed by the applicant, which perhaps unsurprisingly was rejected by the tribunal. The conditions in subsection 1c can be proposed by the applicant or by the respondent or by the tribunal itself.
I'm sorry, you'll have to take me to that when you come to it, because did the upper tribunal didn't consider 1c at all, did they?
They raised it in an email before the hearing.
Okay.
But it didn't arise at the hearing.
It's not in the judgment.
No.
No.
It's not in the judgment. The tribunal was well aware of its power under 1c because it sent an email to the parties asking if the focus, well, maybe it's convenient to show the...
No, don't do it in turn, but the fact no one would doubt that the upper tribunal was aware of its power under 1c, but it didn't address 1C in the judgment.
No, certainly
No.
not. No. The other point I wanted to make about subsection 1C is it is not an exhaustive statement of what the tribunal can do when faced with a section 84 application. It's our submission, unlike any tribunal charged with a discretionary power in broad terms. If it considers it reasonable to do so, it can say, we will only exercise this power if the following conditions are satisfied, and that is done from time to time. The difference between a subsection 1C order and a condition of the kind I've just described is the condition would be ad hoc, whereas subsection 1C is built into into section 84 itself, and under subsection 5, any order made under subsection 84 is binding on all persons, so it takes effect in rem, not just an in personam order. So if I can turn next to the tribunal's decision, is in the core bundle, starting at page 111. I appreciate the tribunal has read this, but there are certain points I want to bring out of it. First sentence, the decision says the applicant holds the lease of 2 redundant warehouses in a part of Manchester which is rapidly being developed as an area of modern high-density housing. So the tribunal there and elsewhere refers to the warehouses as redundant warehouses. They haven't been used for a long time. Paragraph 7, the background is explained, with the original lease being granted in 1978, and then a new lease being granted in the form of a lease extension in 1985. Paragraph...
Do you take issue with a description of the warehouses as redundant?
No.
I thought there was a proposal that they might be used for dark kitchens.
Yes, well, the tribunal regarded that as something it couldn't place any reliance on.
But it was something that was put forward by witnesses on behalf of your client.
Yes, but the tribunal didn't accept that. Then paragraph 14 explains the planning application and the fact that £700,000 had been spent and that a resolution to grant planning permission had come from the council in 2021. And in paragraph 15 at the end, it's explained that there was evidence that the proposals were consistent with the local development plan, but that proposition was never in doubt. That addresses subsection 1b. Paragraph 16, the tribunal explains that the council has offered to grant the applicant a new lease of the site for a term of 250 years to facilitate the implementation of the anticipated planning permission, and it would include terms that the council regards as standard. The applicant strongly disagrees and considers the proposed terms to be onerous and thinks they would be unacceptable to any potential funder or investor in the project, and despite protracted negotiations, the parties have so far been unable to reach agreement on terms acceptable to them.
Mr. Jordan, I should repeat that we have read this in detail, and so we've certainly concentrated on the decision. So unless there's something specific you want to point out, I think we can move on.
Very good. I would like to focus on reasons that the tribunal gave for saying that there were practical benefits. You can look at page 123, paragraphs 51 and 52 and 53. These are central to the appeal. So in paragraph 51, the tribunal asks whether by impeding the proposed use the restrictions secure to the council practical benefits. And then it says, the tribunal says, this question highlights the council's dual role as planning authority exercising public functions and its private capacity as landlord on the other. As planning authority, the council does not only object in principle to the development occurring, it has positively and enthusiastically encouraged it. As landlord, it nevertheless seeks provisions within a new extended lease to which the applicant objects. The purpose of those provisions, the council says, is to ensure the development is completed and within a reasonable time. And then the principal provisions are explained, and the forfeiture provisions are explained, and Mr. Rose took particular exception to those provisions. And then paragraph 52, we've not been asked to consider the reasonableness or otherwise of these conditions, to which we've referred in only the most general terms. However, it's clear that the council's ability to rely on the restrictions within the lease to prevent the applicant from carrying out the development without agreeing to provisions intended to secure the council's development objective does secure a practical benefit. Mr. Hutchings submitted that practical benefits for the purpose of the Act must be direct rather than peripheral benefits secured by covenants, and the benefits were not practical if they were merely pecuniary in nature, i.e. if the only benefit derived from the restrictions was enabling the council to extract a higher premium for agreeing to their relaxation. It is the restrictions themselves that will secure the practical benefit and not the ability of the council to bargain them away. We accept Mr. Hutchings' propositions, but we do not accept their system in this case. The council is not simply seeking to obtain a monetary advantage or relying on the covenants as an obstacle which the applicant must negotiate away. The council is using the covenants for their intended purpose, namely to afford a significant degree of control over the development. So the tribunal here clearly thought the crucial question was the council's motivation. Was it simply using the covenants to obtain a monetary advantage? And the answer to that was no. They were also using the covenants to afford control so as to ensure that the applicant had to agree to the provisions that they wanted in the new long lease. And then in the first sentence of paragraph 53,
no, it doesn't say that, does it? It says, council is using the covenants for their intended purpose, namely to afford it significant degree of control over the development of the site. Doesn't
Yes.
specifically say in relation to a new lease.
no, it doesn't specifically say in relation to a new lease, but read with paragraph 51, which explains the control that the council was asserting. That is the practical benefit that is identified, the ability to control, either it's control simpliciter, the power to control the development of the site by itself is regarded as a practical benefit, in which case that's wrong because mere control by itself can't be regarded as a practical benefit, or it's to be read together with paragraph 51 and as meaning that the benefit to the council was it could insist on the development taking place under the new 250-year lease which the council wanted the applicant to enter into.
Isn't the purpose of the provisions, as it says in the middle of paragraph 51, to ensure the development is completed and within a reasonable time?
Yes. That was what the tribunal held, that the practical benefit. What the tribunal did not do is make a comparison between keeping two redundant warehouses in place and carrying out the development. It made a comparison between carrying out the development under the existing lease without the protections that the council wanted in their new lease and the development going ahead under the new lease. And it said that the ability to steer the development into taking place under the new lease was the practical benefit that the covenants afforded to the council.
But it doesn't say that. Do carry on, but I can't see, I just want you to know I can't see where it says that.
It doesn't say that in so many words,
No,
lady. I
it
accept
doesn't.
that. But either it means control simpliciter, which is what one could read the last sentence of paragraph 52 as meaning the benefit was simply control. But if it doesn't mean that, then it must mean the ability to control the development by requiring it's carried out in the way that the council wanted it to be carried out. In paragraph 60 on page 125,
But sorry, you took us to 53 as well, and there it's considering whether the benefits are peripheral.
in paragraph 53, it said that the covenants allow the council to influence the form of the development. Now, that can't mean the physical form of the development because that was controlled tightly by the planning permission, which required both the resolution to grant and the final version condition 2 has a long list of drawings and plans that the development has to be carried out in accordance with, and there are numerous other conditions governing the physical form of a development. So form there can only mean the form of the development in terms of the legal structure under which it's carried out. In paragraph 60,
Well, can we just go on to 53? Because there is a specific reference here to the lease, isn't there? It would no doubt also be commercially desirable for a new longer lease to be granted.
yes. So there are two advantages of the new lease. One is it allows it to influence the form, i.e. the legal structure of the development.
But then it goes on, that would be the case, whether or not the restrictions in the current lease impeded development.
Yes.
So it seems there, does it, or not? I'd like your submission on it, that actually what the upper tribunal is saying, that yes, one can see that it will be desirable for there to be a new lease, but that is the situation because of those only 60 odd years left. But that is not what they're focusing on. You would say it is.
Well, lady, the possibilities here are that control by itself, if one reads influencing the form of development as meaning the physical form of a development, which is the only place that phrase is used, that can't be right, because I can show the court the planning permission, I can show the court Mr. Rose's evidence about the resolution to grant the planning permission, but it's clear that it was full of conditions imposed by the council as planning authority about the physical form of a development. So the form of the development must be referring to something else and in context, and the only thing that's been mentioned before in the decision is the provisions summarised in paragraph 51, the form in the sense of the new lease, which will enable the council to require the development to start within a set time, finish within a set time, and give it the right to forfeit if those things don't happen.
And the milestones.
The milestones.
That's the form, is it?
Yes. But if what the tribunal meant was it allowed it to influence the physical structure, then there's no evidence for that. That wasn't the basis on which the council's case was put. That wasn't what the evidence was about. There was no suggestion that the planning permission was inadequate as a way of controlling the physical form of what was going to be built.
But what do you make of the rest of paragraph 53?
Paragraph 53 is making the point that quite independently of the covenants and the lease, there was a commercial desirability for a long lease. But that had nothing to do, that was a separate issue. The commercial desirability, the money value or the other value of getting a long lease was something separate. That wasn't what the tribunal was focusing on. That's all that the remainder of paragraph 53 is saying. Meeting Mr. Hutchings' argument that the council were in it for the money, and the tribunal is saying, well, there is a money value in a longer lease, but that has nothing to do with the issues that arise under section 84.
You're taking us on to paragraph 60.
If I may. If I can, so the tribunal first decides that measured in monetary terms, this is the third sentence, in monetary terms the restrictions do not by impeding the development secure to the council the practical benefit of substantial value. Then they deal with substantial advantage. The nub of the application is about the control the restrictions secure to the council as a local authority. We satisfy the council's concerns about the viability of the development of venue and the conditions it seeks to impose address its wish to see the development commencing and being completed within a reasonable period. Again, nothing about the physical form of the development. We have no view as to whether the proposed periods are realistic or reasonable, but that isn't the issue before us. The question is about the extent of the advantage which restrictions secure for the council by preventing the development from going ahead unless the applicant satisfies its concerns. Concerns are not pecuniary in nature, but are aimed at ensuring one of the last pieces of development jigsaw slots into case. We're satisfied that this control is a substantial advantage and the application on ground AA therefore fails. So here again, the tribunal focused on the council's motive. They weren't doing it purely for the money. Its concerns were genuine. Didn't say that the concerns were correct, only that they were genuine, honestly held, and not merely a pretext for trying to get more money. In the respondent's skeleton argument, it said that the upper tribunal held that the council was rightly concerned, but that isn't so. All that the tribunal said is it was satisfied that the council's concerns were genuine, and i.e. not a pretext. And the tribunal didn't say it was a practical benefit for the council to be able to insist on keeping in place the 2 redundant warehouses. They didn't make a comparison between the status quo and granting the modifications. That's not the way the case was presented or decided. Rather, in paragraph 52 and in the penultimate sentence of paragraph 60, they said that the practical benefit was the ability to exert control to ensure that the 2 tower blocks of flats were built, that the one of the last pieces of the development jigsaw slots into place. That does support my submission on the interpretation of paragraph 52 as to what the tribunal identified as the practical benefit. And then the tribunal has seen the 2 grounds on which the tribunal said that if it did have jurisdiction and if it had a discretion to exercise, it would have declined to exercise that discretion in favour of the applicants. And they say that they would have followed the same approach as the Lands Tribunal for Scotland in the Caledonian case, which they quote. And then the other reason is in paragraph 63, when they said they would be reluctant to use the tribunal's discretionary power in a manner which would be liable to disrupt continuing negotiations. So those were the 2 grounds they said on which they would have refused to exercise their discretion. If I may then turn to the errors of law that we say the tribunal made in relation to jurisdiction. The first error of law is that the tribunal was wrong to say that the ability to impose terms on how a development is carried out is a practical benefit for the purposes of subsection 1A, because the practical benefits resulting from impeding a reasonable user must be benefits that result from the user not taking place and not the benefit of imposing controls on how the user is put into effect.
So you're saying imposing terms on how a development is carried out is not a practical benefit. The practical benefit has to be retaining the restriction and preventing the development.
My lady, yes, exactly.
Excuse me.
That doesn't mean the tribunal can't, at the discretionary stage, focus on what conditions are needed for the reasonable protection of the objector. Of course, it can, both under subsection 1C and as part of the general exercise of its discretion. And that is how section 84 allows for the need for conditions to be imposed on the implementation of the reasonable user for the protection of the objector, not by treating the ability to control the implementation of the reasonable user as being itself a practical benefit. And even if that argument is rejected, we submit that the other error was that it's wrong to say that the ability to require that the development is carried out under a new long lease was a practical benefit for the purpose of subsection 1A. The new lease could only be granted if the existing lease was surrendered, and the development could only be carried out if the covenants in the existing lease ceased to apply. And a benefit that can only be realised in return for restrictions being released is not a benefit secured by impeding the reasonable user, it's a benefit secured by allowing the reasonable user. And I start by way of supporting those submissions by taking the court to the Stockport case in the authorities bundle, tab 24. This is a decision of the Court of Appeal in 1983. Stockport Council had land and sold it subject to a covenant not to use for land other than for agriculture. The owner of the land was a developer who wanted to build 42 houses on the land and applied to the Tribunal under Ground AA. Stockport Council retained a housing estate adjoining the land. Some of those houses had pleasant views across the land. The council claimed that the benefit of the views was such that it could not be quantified in money. Alternatively, it said it would get a lower price when the right to buy was exercised by its council tenants. And it said that if the application was granted, it should get compensation equal to a proportion of the development value which would be unlocked by modifying the covenant. And the Lands Tribunal concluded that the only detriment the council would suffer was that it would get a lower price when the right to buy was exercised from 11 of the houses held by its tenants. So it awarded £2,250 compensation for that. And the council appealed, but the appeal was dismissed. One of the issues was whether the ability to require a payment in return for releasing the covenant was a practical benefit for the purposes of subsection 1A. Lord Justice Dillon dealt with that at page 343. Could I ask the court to read the last paragraph on page 343 over to the top of the next page?
It has, however.
Yes. Lord Justice Griffiths agreed with Lord Justice Dillon. Lord Justice Evely gave his own judgment, agreeing with that, but making an additional point. And if I can ask the court to turn back to page 341. In the sidelined passage on page 341, he said the benefit envisaged must be a practical one as opposed to a pecuniary one. So that was the same reason given by Lord Justice Dillon. And then he went on, that is the practical benefit which is afforded by the observation of the covenant. Thus, the subsection exempts from discharge or modification those covenants whose preservation will secure a practical benefit. Bargaining power is only a benefit when it results in the receipt of the price upon the covenant being discharged. Such a benefit cannot be of the kind contemplated by the subsection, for it results from the discharge and not the continuation of the covenant. And he said the same on the next page. If I could ask the court to read the sidelined passage on page 342. And our submission is that the additional reason given by Lord Justice Evely, which neither of the other judges commented on, is a sound reason. It fits with the structure and purpose of subsection 1A, and it ought to be adopted by this court. The narrow basis on which Lord Justice Dillon and Lord Justice Griffiths decided the case was sufficient in Stockport, but the broader approach adopted by Lord Justice Evely gives effect to the policy of section 84. It's easy to think of a case where what the objector wants in return for allowing the development is not money, but something which does improve their amenities. You might have a case where the objector, with the benefit of a restrictive covenant, was willing to consent to a development in return for being granted a right of way over the applicant's property or being given some land belonging to the applicant to make the objector's garden bigger. Those are practical benefits. They're not merely financial, and one could say they were secured by the covenant impeding the development. But that doesn't fit with the structure and purpose of Section 84. Whether the benefits which the objector seeks to achieve are in the nature of amenities or in the nature of money, they shouldn't be treated as practical benefits for the purpose of Section 84, because, as Lord Justice Evely said, they result from the modification or release of the covenant and not from its preservation impeding the reasonable user. The approach taken by Lord Justice Evely is supported by the two leading textbooks, which we have quoted in our skeleton argument. Perhaps it's unnecessary to turn those up.
Can you just remind us where they are in the bundle?
Yes, of course, my lord. I'll go there very quickly. The first one is at tab 5, page 49. Paragraph 20.22, this is a book called Scammell and Gastowitz on land covenants. And paragraph 20.22, the footnote refers to Lord Justice Evely in Stockport. And the other leading textbook is at tab 4, page 38. Paragraph 13.027, the quotation from Reed Diggins' application, where the tribunal said in the second sentence, the practical benefit is secured by a restriction when it flows directly from the observance of that restriction. It is the prevention of the consequences of breach of a restriction which may secure a practical benefit. In the present case, the benefit identified by the tribunal was not preventing the development from happening. The benefit was ensuring that the development took place on terms that the council genuinely thought were needed, i.e. a 250-year lease with milestone obligations and a forfeiture provision. And in our submission, that wasn't a benefit that flowed from the observance of the restrictions. It flowed from their being replaced by a new, quite different set of restrictions. Our submission is that Lord Justice Evely's approach gives effect to the purpose of Section 84. On that, can I show the court two cases? The first is at tab 22. This is Shepherd and Turner, decided by the Court of Appeal in 2006. It was an application by the owner of a house for modification of covenants to allow the construction of a bungalow in their garden, where the tribunal granted the order and the neighbours who had the benefit of the covenant appealed unsuccessfully. And Lord Justice Carnworth, whom the other members of the court agreed, explained the purpose of Section 84, beginning on page 316. If I could ask the court to read paragraph 16 and 17 there. Paragraph 17 identifies the mischief which subsection AA is directed at, either frustrating development of land or leading to a situation where excessive sums have to be paid to obtain release. And the predominant consideration was the benefit conferred by the covenant in unreasonably impeding the use of land. The other case is at tab 7. This is Millgate Developments and Alexander Devine Children's Cancer Trust, decided by the Supreme Court in 2020. It was a case where the land in question was subject to a restrictive covenant preventing building and restricting use to open space for parking vehicles. The developer acquired that land and also other land not subject to any covenant. Knowing of the covenant but ignoring it, the developer built 13 houses on the land which was subject to the covenant. Next doors was land which had the benefit of the covenant, which was owned by a charity on which it was building a children's hospice. The developer applied under Section 84 to modify the covenant to allow it to use the houses, and it succeeded in the tribunal, Judge Martin, Roger QC and Mr. Francis, on the public interest limb of ground AA. The tribunal held that in impeding the use of the houses, the covenant was contrary to the public interest and exercised its discretion in the developer's favour. And the Court of Appeal held that was wrong in law and reversed it, and on further appeal the Supreme Court agreed that the decision was wrong in law but for different reasons to those in the Court of Appeal. At one point where the Supreme Court disagreed with the Court of Appeal was whether the developer's cynical breach of the covenant was relevant to deciding whether the tribunal had jurisdiction, whether in impeding the use of the houses, the covenant was acting contrary to the public interest. And the Supreme Court held it wasn't relevant to jurisdiction, but only to discretion. And the reason is given in the judgment of Lord Burroughs, page 79. Paragraph 44. And he says there, in the second sentence, the manner of the breach of the restrictive covenant, i.e. whether the breach was cynical or not, is irrelevant, because that tells us nothing about the merits of what the burden land is being used for or will be used for. This is not, of course, to deny that the manner of the breach, the cynical breach by the applicant, is a highly relevant consideration when it comes to the discretionary stage of the decision, but it's irrelevant at the jurisdictional stage. And then on page 80, at paragraph 46, he says section 84(1)(b) is consistent with the interpretation advocated by Mr. Hutchings, in which I agree, and then he quotes it. And then he says at the top of the next page, the main body of this emphasises, as one would expect for the resolution of a land use conflict, that the development plan and patterns of planning permission in the area are relevant considerations. The last phrase, any other material circumstances, means that the circumstances must be material to the question one is asking. And I've clarified in paragraph 42 above that the question one should be asking in relation to the contrary to public interest jurisdictional ground is whether the impeding of the reasonable user of the land by the continuation of the restrictive covenant is contrary to the public interest. So the phrase land use conflict was Lord Burroughs' phrase to summarise how ground AA works. On the one hand, you have the reasonable user proposed by the applicant. On the other, you have the effects of that user on the persons who have the benefit of the covenant, and there's a conflict between them. And Section 84 gives the tribunal power to resolve that conflict in the applicant's favour if either impeding the proposed reasonable user is contrary to the public interest, or if the ability to prevent the applicant's proposed user doesn't secure any practical benefits of substantial value or advantage. And the approach here to the phrase material circumstances shows that you have to construe the language in Section 84 having regard to the question being asked, and the same is true of the phrase practical benefits. And the other point I wanted to refer to in this decision is the one on page 84, paragraph 52. I also accept that the upper tribunal in the trustees of the Green Masjid case was correct to say that once a jurisdictional ground has been established, the discretion to refuse the application should be cautiously exercised. We rely on section 84(1)(c) as supporting the submissions we've made. As the court has seen, subsection 1(c) says that the tribunal can impose additional restrictions if the applicant accepts them, if it considers it would be unreasonable to allow the development to go ahead without imposing additional conditions. And we also submit that in addition to that, as part of the exercise of its discretion, the tribunal is entitled to say that specific conditions will need to be satisfied if its discretion is to be exercised in the applicant's favour. If I could ask the court to turn to tab 13, please. I rely on this as an analogy. It's not a case about section 84, it's a case about a different statutory provision giving a tribunal a discretionary power, in this case in the context of service charges. As the court may have come across, residential service charges are subject to an elaborate regime for the protection of tenants, and one element of that protection is that if the landlord wants to recover more than £250 per tenant in the contribution to the cost of works to the building, the landlord has to go through a consultation procedure under Section 20 of the Landlord and Tenant Act 1985. The tribunal, at the time this case was decided, it was called the Leasehold Valuation Tribunal. Now it's the first tier tribunal, at least in England, has power to dispense with compliance with the consultation requirements. And that power is set out in paragraph 9 of the judgment of Lord Newberger on page 166B. Where an application is made to an LVT for a determination to dispense with all or any of the consultation requirements in relation to any qualifying works, the tribunal may make the determination if satisfied that it's reasonable to dispense with the requirements. And in this case, the landlord failed to comply with the consultation requirements and the tribunal refused to dispense. The landlord appealed ultimately to the Supreme Court, which held the tribunal had been wrong, and the court ordered dispensation subject to two conditions. One had been offered by the landlord in the tribunal, and that was to not seek to recover any contribution to the first £50,000 of the works, and that was to reflect any disadvantage suffered by the tenants as a result of the failure to consult. And the other, imposed by the Supreme Court and raised for the first time in the Supreme Court by the court itself, was that the landlord should pay the reasonable costs of the tenants insofar as they reasonably tested its claim for dispensation. And the question of conditions was addressed by Lord Newberger in paragraph 53, which begins on page 167 of the bundle. And if I could ask the court to read paragraphs 53, 54 and 55, please. And we submit the same is equally true of section 84. if the tribunal considers that there is some condition or some conditions that would need to be satisfied before it considered it reasonable to exercise its discretion, it can indicate that, and then if those conditions are accepted, the order will be made, and if they're not accepted, they won't be made. The tribunal has in fact done that in some cases. We mentioned 2 examples in our skeleton argument. We've included one in the bundle of authorities. That's at tab 12. And we cite this as an example of the correct application of section 84. It was an application to modify a restrictive covenant to allow the completion of a first floor extension to a bungalow. The covenant said that only buildings 1 story in height could be built, but the applicant wanted to extend the bungalow into a first floor. It was objected to by 2 of the neighbours on various grounds, mostly interference with their privacy. The application succeeded. The tribunal didn't suggest that the ability to control the use of the applicant's land was itself a practical benefit. Rather, the tribunal focused on whether the objectors would be better off in a practical way if the extension was not built. I can ask the court please to look at page 159, paragraph 43. The court could just read the first 3 sentences there, please.
I'm sorry, what was the reference again?
Page 159, paragraph 43,
Thank you.
the first 3 sentences.
I'm sorry, thank you.
And nor did the tribunal ask whether the objectors' concerns were genuine. It asked if they were valid. If I can ask the court to look at paragraph 44. The tribunal did what it's supposed to do under section 84. It made its own assessment of whether the effect of preventing the proposed development from going ahead would be of substantial advantage to the objectors, and it said it wouldn't, disagreed with them. And then it concluded that in paragraph 48 on the next page, that the benefits are not of substantial value or advantage, so ground AA is made out, but there will be some, albeit slight, adverse effect on the objectors, so ground C is not made out. And then on the next page, paragraph 50, he says, finally, at the end of the hearing, I asked the parties to consider proposals for a suitable programme for additional screening along the rear boundary between Streamside, which was the applicant's property, and Glen Cottage, which was the objector's property, to be implemented if I were minded to grant the modification sought and provide their submissions by the end of January. And the applicants retained a specialist landscape management company and obtained from them, in my view, an eminently sensible and worthwhile boundary landscape management scheme. And then in paragraph 51, he says in the 3rd sentence, I propose therefore to determine that subject to satisfactory completion of the Berry landscape management scheme, the restriction shall be modified as follows. So that wasn't a subsection 1C restriction, it was a condition that the tribunal member thought needed to be satisfied before he was willing to exercise his discretion in the applicant's favour. Similar to the approach taken by the Supreme Court in Dejan and Benson. Another example is at tab 9, concerned a leasehold application about premises in Berkeley Square held under a long lease which said they could be used as offices only, and the tribunal made an order modifying the covenant so that the premises could be used as a members' club. And I could ask the court to look at page 123, paragraph 122. I could ask the court to look at paragraphs 122 and 123. And
So
then,
all of this shows that, of course, there is such power, because
Yes.
that's what Section 84(1)(c) says, and that it can be something which, when determining whether the power should be exercised, the tribunal considers and puts forward to the parties and says, this is what we propose to do. And in this case, for example, the Berkeley Square one, it was at a stage where further submissions were requested in relation to it. So it was perhaps, it would seem from paragraph 123, late in the day. But submissions were made in relation to it. And so please just encapsulate how you say that helps you in relation to section 84(1)AA. I know you've said you already said it, but just crystallise it for me.
just as in Dejan and Benson, it's not an all or nothing situation. It's not the tribunal has to either modify or not modify. If the tribunal is satisfied that the user is reasonable and the covenants impedes that user, and preventing the user from taking place doesn't afford any practical benefits, or at least doesn't afford any of substantial value or advantage, then it can ensure that the development is carried out in a way that affords protection to the objector. And if it's not satisfied, then it can refuse in the exercise of its discretion to make the modification order. So that, it meets the objection that my argument doesn't allow the tribunal any way of controlling how a development is carried out. Because if I'm right, if both parties want the development to be carried out, then the jurisdictional ground is satisfied under ground AA, and one moves on to discretion. And then the appropriate question for the tribunal is not, is the objector genuine? Do they have a wish, which is a genuine wish to see something happen? But what are the right terms to impose, if any?
You based your argument, well, the first case you cited was Lord Justice Evelyn's dictum in the Stockport case.
My lord, yes.
I think the other side rely on Lord Justice Evelyn in another case, do they not?
Yes.
The Gilbert and Spore case.
Yes. Gilbert and Spore was a case about a beautiful view over the countryside from...
Yes.
Not from the houses which had the benefit of the covenant themselves, but from a pathway or a seat nearby. And the court said that Section 84 was wide enough to encompass benefits that could be enjoyed even not from the benefited properties themselves. And that was the context in which he said that Section 84, the concept of a benefit should be interpreted broadly. And I don't dispute that at all. Practical benefits are broad, but what they don't include is practical benefits which will be enjoyed when the development is carried out in under a different lease to the one that exists. They're practical benefits that are afforded by stopping the development. In Gilbert and Spore, the outcome was the development never happened, so the objectors carried on enjoying the beautiful view, or were able to enjoy it if they wished to.
And so I'm just trying to work through what you're saying about section 84(1)(c), quite clearly power in the tribunal to impose conditions in order, if they are to modify the covenant or in the exercise of their discretion. But in this case, therefore, are you saying that the tribunal missed a trick and should have said, aha, yes, we are willing to modify these covenants or to exercise our discretion, and in order to do so we should impose conditions, and if so, on the basis of what it would depend on the basis of the kind of evidence and the quality of the evidence they had before them. They found in this case that there were genuine concerns about the risk of completion of the project, to put it that in general terms. And so, are you saying that the, I don't think you are, but is the consequence of all of this that actually the upper tribunal should have imposed conditions, and those conditions surely, in the circumstances of the evidence they heard, to the extent that it was of sufficient quality, might have been exactly the kind of terms which were being negotiated, and they would have been imposed as conditions in relation to the old lease. And so you'd be in exactly the same position.
My lady, my submission at the moment is the tribunal made an error of law in saying it had no jurisdiction, which is what it actually decided.
Mm.
So I need to get over that obstacle first before we get on to... I need to persuade this court that the tribunal did have jurisdiction contrary to what it decided. If I can't do that, then that's the end of the appeal.
Mm-hmm.
If I can do that, then the tribunal made an error of law. It should have said, we do have jurisdiction. And then I need to address the two grounds that the tribunal gave as to why it wouldn't have exercised its discretion. If I can overcome those, we get to the point where the tribunal's decision is set aside, and this court then has to decide what to do. And it will be my submission when I get to that point in my argument. What the court ought to do is simply make the modification order. The alternative, if the court isn't satisfied that that's the right course, would be to remit the case to the tribunal to remake its decision freed from its errors of law. At that point...
And what about Clause X?
Yes, Clause X is what I'm asking the tribunal to... the court, I'm sorry, to make by way of a modification order, but the court may say, we're not going to do that, we're going to remit it. I mean, those are the options open to the court, to decide the appeal itself and decide what should happen, or to remit it. That comes logically at a later stage in the argument. My submission is that the court should make either Clause X, or if the court prefers...
But Clause X is nothing, is it? Because it just says, in effect, you can do it subject to the planning permission, etc., and the planning permission has been granted. So it's an open gate.
Well, it's subject to the conditions in the planning permission.
In the circumstances, it's nothing.
But, my lady, the conditions in the planning permission, which I will take the court to briefly, there are many of them, and many of them have to be satisfied before commencement of a development. Others have to be satisfied before occupation. So it's not like we can just do whatever we want. We have to comply with the conditions in the planning permission. That's what the clause says.
Yes.
Yes. But in terms of meeting the genuine concerns of the council, which the tribunal didn't decide whether they were justified, only that they were genuine, no, there wouldn't be a remedy for the council if building started and then there was some disaster. I mean, nobody is going to start building a building costing hundreds of millions of pounds without intending to see it through to the end. That would be an insane thing to do. But there is always a risk, and even large developers face this risk. We are faced with a 2008 type crisis where funding is cut off, or a 1973 to 75 type crisis where banks go down and the money just isn't there. There could be a hiatus in the building process. It could be quite a long hiatus before you can get the money together and start building again. And what my clients objected to throughout this process was being faced with a situation where, if that happened, all the money they'd spent could just be confiscated by the council and the value of the site appropriated. So if we got onto the question of what conditions there should be, we say there shouldn't be any, but if we did get onto that, we would in effect be happy to agree to any reasonable conditions, provided they didn't include a confiscation clause, a forfeiture clause. But the tribunal never got to that point.
Thank you.
Could I take you back to your jurisdiction point?
My Lord,
Forgive me if I'm being too slow, Mr. But looking at the statutory provision, where precisely do you say the tribunal went wrong in determining that it did not have jurisdiction?
the tribunal's identification of the practical benefit was something which is not a practical benefit for the purposes of subsection 1A as a matter of its correct interpretation, because it can only be a practical benefit. It is something that will be enjoyed if the reasonable user is not put into effect and the covenants remain in place. It's not concerned with the practical benefit in terms of controlling the manner of the development. That is not a practical benefit. And I rely on subsection 1c to support that argument. It is Lord Justice Evelegh's interpretation of subsection 1a, a benefit that you get when you give up the covenant, when the covenant is released or modified to allow the thing to happen. That is not the type of benefit that can count as a practical benefit for the purposes of subsection 1a. Otherwise, in many cases, the tribunal would have no jurisdiction because although it may be the case that once the development is completed, it will cause no harm to the person with the benefit of the covenant. The ability to control how the development is implemented and put into effect is a substantial benefit. And it would mean that in many cases the tribunal would simply have no jurisdiction. And that would be an incorrect reading. It would be contrary to the statutory purpose of Section 84 and inconsistent with its structure because it's in impeding the reasonable user that the practical benefits have to arise, preventing it from happening. Will the objector be substantially better off in practical terms if the proposed change of use or building works never happen? Not will they be substantially better off if they are carried out subject to particular controls.
Does it turn to any extent on the meaning of the word impede?
Yes, to some extent. I mean, impede. We have the dictionary definition in tab 3. Oxford English Dictionary definition. Impede is to retard in progress or action by putting obstacles in the way, to obstruct, to hinder, to stand in the way of.
Yes.
So here it means stopping.
Does it? Why? I mean, it's not
Prevent.
retard in progress. Hinder.
The mischief, as the court has seen, which the introduction of subsection AA and its associated 1A, 1B and 1C were introduced, was because people with the benefit of covenants were preventing the development of land in circumstances where that was not in the public interest, or they were demanding excessive sums which were not subject to any controls by any outside body. And AA and its associated subsections were introduced to ameliorate that, to facilitate the development of land in the public interest in circumstances where preventing the development from going ahead didn't afford substantial practical benefits. It has to be read with that purpose in mind. My Lord, my Lady, one case that the Council relies on in its skeleton argument, which I did want to look at, is at tab 15, because it betrays what in my submission is an error of law.
Mm.
16.
Well, I entirely accept that as a matter of ordinary English.
This is 16. This is the passage I was referring to.
Tab 15.
15. Oh, right.
Edgware Road.
Edgware
Sorry,
Road.
Edgware Road.
This was a case about a building on the Hyde Park estate held under a long lease which prohibited residential use, and the tenant wanted to change the use to use as what was called a pod-type hotel, a hotel with no windows, which the landlord, the Church Commission has opposed successfully, and I have no quarrel with the decision in the case, but one of the things said by Mr. McRae, the member of the tribunal, which the council relies on, I do take issue with. That's on page 201. Paragraphs 125 and 126. Perhaps I could ask the court to read those two paragraphs. And the argument is that if you have a lease covenant that allows the landlord to say you can't do something, that itself is a practical benefit because it allows the landlord to control what the tenant can do. And in my submission, that is inconsistent with the operation of Section 84 AA and 1A properly understood. It's not concerned with what is in reality not a practical benefit but an abstract benefit of control. It focuses on the particular reasonable user and whether in impeding that particular user the covenant secures a practical advantage, not on whether it's simply wrong in principle to treat the right of control as itself being a practical benefit. That is inconsistent with the language and purpose of Section 84.
But at the end of paragraph 126, what Mr. McRae says is, by preventing hotel use in a location where the commissioners don't wish to see it, that is what secures, that's why the restriction secures practical benefit. And that is focusing on the particular use in the particular location. So why do you say that he's made an error there?
Well, he goes on to explain why the objection to hotel use was a valid one, why it would be harmful to have hotel use. That is the legitimate question. But what he's saying in paragraph 126, at least taken literally, and certainly in the way that the council rely on it in their skeleton argument, it is the mere fact of control itself, whether or not having a hotel would be harmful. The ability to stop it is regarded as being a practical benefit. And that can't be right in my submission. It's only a practical benefit for the purpose of subsection 1A.
So being able to stop a hotel is a practical benefit. If you don't want a hotel in a particular location.
Well, my lord, every covenant in that case affords a practical benefit because every covenant allows you to prevent something from happening. A covenant not to extend a bungalow into the first floor affords a practical benefit. A covenant that only one house is to stand on a plot of land affords every covenant, every restrictive covenant that's ever been entered into affords control to the covenantee. That's its whole object and effect. So to interpret subsection 1A as meaning that any ability to control the use of land is itself a practical benefit is to denude the phrase of any meaning.
Well, its control there is used in the context of the previous sentence, isn't it? Or the previous part of the sentence, as an important tool of estate management. Not just control in a vacuum, it's control as part of its estate management toolbox.
My lord, yes. I mean, if you have more than one property, if you have many properties, and you manage the estates, then the covenants give you the ability to control what happens on any part of the estate. And in one sense, one can see that is a benefit. But for the purposes of Section 84, it can't make any difference whether your ability to control relates to one bungalow or 100 different properties. Either way, if you treat mere control by itself as a practical benefit, then there is simply, then every covenant affords a practical benefit, and the requirement that there be a practical benefit loses any meaning.
Well, do we have to think about the qualification to practical benefit, substantial value or advantage?
Yes, that follows once you've identified whether there is or isn't a practical benefit.
Does it? I mean, might that not be a distinction between the example you've given of a landowner who has 2 properties and a more substantial estate? A practical benefit of substantial benefit, value or advantage. Why do you divide? Why do you not consider that phrase as a whole?
Certainly in this case, and in many cases, the tribunal asks, is there a practical benefit, and then are the practical benefits of substantial value or advantage? That is a fairly, in our own case, that's what the tribunal did. Fairly standard approach. And if one reads practical benefit as including controlling the use of land, then that part of the phrase becomes irrelevant. The only question is whether impeding the use affords something which is valuable or advantageous.
And so, just to crystallise all of your arguments really in a few words, what is section 84(1) driving at in relation to practical benefits of a substantial value? If it isn't control, what in addition does it need to be? I know you say specific user, but in this case, in the case about the hotel, it was a specific user.
Yes.
What in addition is necessary?
In some cases, it's said that the specific change of use or building works themselves will be harmful. In some cases, it's said that although this particular change of use will not be harmful, nonetheless, it will change the context in which future applications under Section 84 are considered. What's called the ratchet effect. Is that not control? Normally, it's the ratchet effect on the estate. You start off with one pod hotel, and suddenly you have lots of them, and the whole character of the estate has changed, which is disadvantageous to the owner of the estate. It's called the thin end of the wedge, or the ratchet effect, and it's often relied on in Section 84 cases, and it's a perfectly valid practical benefit of ensuring that there isn't a widespread change in the character of an estate. But it's all about the consequences of the use, focusing on what happens if the use happens, not on treating the ability to control the use itself as being a benefit. It's only a practical benefit if the covenantee will be better off in some practical way if the development doesn't take place, either because of the impact of the development itself or because of the cumulative knock-on effects of that in encouraging other similar developments to take place. And I accept, going back to the point that my Lord Justice Baker made, that the word impede could, in an appropriate setting, include hinder or slow down or impose controls. But in my submission, in the context of subsection 1A, that isn't what it means. Because otherwise, every case where there was an issue about how a development should be carried out, the tribunal would have no jurisdiction, and that would be an inaccurate interpretation. The right interpretation is that you focus on a reasonable user. You say, is the ability to stop that something that will leave the objector substantially better off in a practical way? And if the answer to that is no, the tribunal has jurisdiction, and it can deal with the impact of the carrying out of the development as part of the exercise of its discretion. In the light of the objection to reliance on subsection 1C, I'd like to show the court how the point was put in Mr. Hutchings' skeleton argument in the tribunal. That's in the supplementary bundle at page 80. And if the court could please read the highlighted paragraphs on that page.
Sorry, I missed the
Page
page.
80. So that's the way the argument was put in the tribunal, and it is correct that no reference was made to subsection 1c. But the submissions that I am making are the same that were made to the tribunal. I am seeking to fortify them by relying on subsection 1c, which I submit is a legitimate thing for me to do. It doesn't involve taking a new point, it just involves fortifying an existing point with additional submissions. But if it is a new point, then I ask for permission to be allowed to advance it on the ground that it is a pure point of law. It doesn't take the council by surprise, since it was in our application for permission to appeal. They've known about it for a long time. Couldn't have affected the way the evidence was called. The other point that we make is that even if what we've said so far is incorrect, nonetheless, the benefit that was identified here as flowing from preventing the development from going ahead under the lease was that it would enable the council to secure the last piece of the jigsaw by having the development carried out. And according to the council, that could only be done if a new long lease was granted. So the benefit that the council would enjoy if the reasonable use of being carried out under the existing lease was prevented could only be enjoyed if this new long lease was entered into. The council never sought to exercise control of a development under the existing lease. Its position was consistently that it would only consider allowing the development to take place under a new 250-year lease. And in our submission, the ability to exercise control of a development by granting a new long lease is not a practical benefit. By analogy with the Stockport case was simply about a sum of money. This is not about a sum of money. It's not a pecuniary or not purely a pecuniary advantage, although there would obviously be a premium for the new long lease. But nonetheless, it is a quid pro quo for allowing the development to go ahead. And so, for those reasons, we submit that the tribunal was wrong in law to say that it had no jurisdiction to grant a modification order in the present case. Unless I can help further on that point, I propose to move on to the question of discretion.
Thank you.
There is a question for this court as to how the hypothetical exercise of discretion by the tribunal should be treated. The only judgment I found that addressed that point was the one I quoted in our skeleton argument by Lord Justice Jacob, where he said he wasn't convinced that a hypothetical exercise of discretion should be afforded the same deference as an actual exercise. And in our submission, that is right. It ought to be treated more like an obiter dictum than like a ratio. relevant but not decisive. The tribunal gave two reasons for the hypothetical exercise of its discretion. The first was that the tribunal should be slow to interfere with a local authority which seeks to use its private rights as landlord to promote its strategic development plan and to ensure that a desired development takes place. And if we can look again at the decision at paragraph 62 and 63 in the core bundle at page 125. They refer there to the Caledonian case. The Lands Tribunal for Scotland gave a second reason for refusing the application to modify on the use of the cinema based on the dual function of the objector as both private landlord and local authority responsible for securing development. And then they quote the Scottish Tribunal. Slow to interfere where a local authority in maintaining private obligations was genuinely endeavouring to control a particular environment. And then at 63 they said the tribunal should be equally slow to interfere with a local authority which seeks to use its private rights as landlord to promote its strategic development plan and to ensure that a desired development takes place. And that again supports my submission about what they identified as the practical benefit. It wasn't stopping the development going ahead, it was ensuring that it did go ahead under the new lease. And then they go on to the second point, reluctant to use the tribunal's discretionary power in a manner which would be liable to disrupt continuing negotiations. And then they say, if the necessary jurisdictional conditions have been satisfied in this case, the tribunal the opportunity to intervene in the parties' negotiations, it would, in our judgment, have been unnecessary and inappropriate to have done so. And in the previous sentence, they say, we're in no doubt that the development of the site is capable of being achieved through sensible commercial negotiations. So those are the 2 points I need to deal with. And explain why, in our submission, they were incorrect. The tribunal should have directed itself in our submission in the way that Lord Burrows said in Alexander Devine, namely that once jurisdiction had been established, refusing to grant the modification order was something that should be cautiously exercised. The effect of the tribunal's decision was to leave the applicant in a position where it can only carry out the development by agreeing to enter into a new long lease on the terms required by the council, with no recourse to the court or to the tribunal to determine if those terms are reasonable or unreasonable. Neither the court nor the tribunal have the power to determine the terms of such a new lease, or to decide if the terms required by the council to be included were reasonable or unreasonable. The tribunal clearly doesn't have such power. As to the court, in our skeleton argument, I may just briefly look at that in the core bundle at page.
But that wasn't what the upper tribunal was saying, was it? Because it had already said earlier that it wasn't being asked to consider whether any of the terms which were a matter of negotiation were reasonable or otherwise, and actually it didn't have details in relation to that, I think.
No, it had no power to decide.
Of course.
It would have been futile.
And it wasn't focusing on that.
It was in our submission, it was irrelevant because the tribunal couldn't decide whether the terms were reasonable or unreasonable. It has no jurisdiction to make a determination of that kind. No. All it can decide is do the covenants in impeding the proposed user for substantial practical benefits, and if so, should it, in the exercise of its discretion, make a modification order? The submission I made.
They were saying they would be left as a result of the approach in relation to discretion. Your clients would be left in a situation in which they would have to enter into a lease on the terms being offered. But that is not what is being said, as I understand it. First of all, quite rightly, and I think we all agree, quite rightly, the upper tribunal didn't consider and had no power to consider, and it was irrelevant to it, whether those negotiated terms, which were still in negotiation, were reasonable or not. And what it's saying at 63, for example, is we wouldn't have exercised our discretion in a way which would interfere with that negotiation, not that your clients would be left in a situation in which they had to do one thing or the other.
Well, my lady, by not interfering with the negotiations, the tribunal left the matter as it was prior to the application to the tribunal. I'll show the court what that was. But essentially, we had said we'd like a new long lease. The council had said we're happy to give you one, here are the terms. We said those terms
thanks.
are completely unacceptable. Negotiations came to an end, and then a fresh application was made, this time not for a new long lease, but for consent under the existing lease, which the council did not engage with, never engaged with. All the council said is, we will give you a new 250-year lease. That's all we're willing to discuss. And that's where the tribunal has left the parties. So either the development, unless there's a change of heart on the part of the council, of which there is no sign whatsoever, or a change of heart on the part of my client, of which there's no sign whatsoever, the development will not take place because my client won't enter into the lease on the terms that the council wants, and the council won't give up those terms. So that's where we are left. That's the position. And if this court dismisses the appeal, that will be the position. If the court allows the appeal, then matters will be different. That will substantially increase the chances of the development taking place. Not guarantee it, of course, but substantially increase. The point I was trying to make, perhaps rather clumsily, was that there is no third party who can review the terms of a new lease. The council is a public body, but judicial review is not available in respect of decisions made by a local authority in respect of matters of this kind, unless there's something like fraud or corruption. It's obviously not suggested here. Simple unreasonableness or intransigence is not something the courts will investigate. We said that in our skeleton argument. That proposition is agreed, so I don't need to take that any further. Can I look at the Caledonian case, which the tribunal is going to follow? That's in the authorities bundle at tab 11. So tab 11 is a decision of the Lands Tribunal for Scotland in 1984. It was a case where there was a local development corporation called the East Kilbride Development Corporation, and the applicant had a cinema in its area, and it wanted to use the cinema for bingo. And the development corporation said it wouldn't give planning permission for that, and it also refused to agree to a modification or discharge of a leasehold covenant that prevented such use. And the reason for that was the corporation considered it would be damaging to its own proposals to have a bingo hall elsewhere in a new leisure complex, which it wished to build. The proposals for the leisure complex have been submitted to and approved by the Secretary of State under the applicable statute, so they were essentially part of the equivalent of the development plan. So the Development Corporation was using its powers as planning authority and as landlord to prevent a use which it regarded as damaging to the development of the land for which it was responsible and contrary to the equivalent of the development plan. Section 84 doesn't apply in Scotland. At the time this case was decided, there was in force Section 1 of the Conveyancing and Feudal Reforms Scotland Act 1970, which is set out on page 142. It's the second paragraph on the page, just over halfway down. Perhaps I could ask the court just to read that, please. And if we can then go to page 145. Perhaps I should start on page 144 just to put it in context. Page 144, where the sidelining begins. The Tribunal said under section 13C it's necessary for us to consider whether all the circumstances use as a bingo club is a reasonable use of the cinema premises. And then they deal with the question of practicability. And it's in that context that the paragraph on page 145 appears. Beginning Mr. McLean. And the Tribunal says that in the Bolton case, Aberdeen Corporation sought by means of a land obligation reinforced by an implied planning refusal to implement their policy decision to disallow betting shops in their housing developments, whereas in this case there is no policy objection to there being bingo facilities in East Kilbride Town Centre. Otherwise, it seems to us that Bolton and the present application are on all fours for both Aberdeen Corporation and the Corporation in this case are seeking by means of land obligations reinforced by their planning powers to control development. In Bolton, we indicated that the Tribunal will be slow to interfere where a local authority in maintaining private obligations was genuinely endeavouring to control a particular environment. And that must be equally so in a case where the authority in question in maintaining such obligations is seeking to carry out a development which is part of their overall plan, which they have a statutory duty to carry out. So the Tribunal held that section 13C was not made out, that the existence of the obligation impedes some reasonable user of the land. They held it didn't. The proposed user wasn't a reasonable user of the land, both because planning permission wouldn't be granted and because it was contrary to the genuinely held view of the local planning authority that it was an undesirable use. They were seeking to reinforce their statutory obligations by using their private rights as landlord. The first point to make about it is that Scottish legislation is in different terms, the point made by the Upper Tribunal itself in paragraph 48 of the decision. The 1970 Act was repealed and replaced in 2003 by a new statute in Scotland which gives much broader powers to the Lands Tribunal for Scotland. And the point was also made by the Lands Tribunal for Scotland itself in the Bolton case, which is at tab 10. This was a case, as the court has just seen, where the applicant wanted to use a shop as a betting shop. And there was a restrictive covenant preventing that, the benefit of which was held by Aberdeen Corporation, which was also the planning authority, and Aberdeen Corporation refused planning permission and also contested an application under section 1 of the 1970 Act. At page 128, in the left-hand column, it's the first break of paragraph about halfway down the page, the new jurisdiction. The new jurisdiction which this Act has introduced bears considerable resemblance to that which is exercised in England under Section 84 of the Law of Property Act as amended. There are, however, material differences in wording. And then on page 129, on the left-hand column, the sideline passage, just to show that the Tribunal is now starting to discuss section 13C, the existence of the obligation impedes some reasonable use of the land. So what follows is in that context. And then on the right-hand column, the last paragraph on that page, In construing section 1.3c, it's necessary to consider it in the context of 1.3 as a whole. The section provides that the tribunal may vary or discharge land obligation in relation to interest in land in which the application is being made on satisfied in all the circumstances. The existence of the obligation impedes some reasonable use of the land. The tribunal was obliged to counsel for all the circumstances of the case, including the precise surroundings. In considering this question, we're not necessarily bound to follow the policy of the corporation, which may indeed change if the majority of councillors come to favour the allowance of betting shops in their council schemes. If a policy of a local authority is sought to be implemented through the medium of proprietary control and the imposition of land obligations, they are not entitled to be regarded differently from any other proprietor in benefit of private rights. Nevertheless, where a local authority or any other proprietor in maintaining private obligations is genuinely endeavouring to control a particular environment, the tribunal will be slow to interfere with that control. The onus is clearly on an applicant trying to upset that control to prove that one or more of the three alternative grounds of jurisdiction has been satisfied. So what the tribunal is saying there is, first of all, that with the 1970 Act, a local authority is not to be treated any differently to any other land proprietor in the benefit of private rights. And then they say that if a proprietor is genuinely endeavouring to control an environment, the tribunal should be slow to interfere with that control. And that was the concept that the tribunal in our case adopted and applied under Section 84. In our submission, that isn't the right approach under Section 84. Whatever may be the case in Scotland, it's not the right case under Section 84, because except in a case where somebody is using a covenant as a pretext, all they want to do is extract a sum of money. But in most cases, that isn't so. In most cases, the objectors are perfectly genuine in their objections. And the question for the tribunal is not, are they genuinely seeking to control the development, but rather the question posed by the statute, which is in enabling them to prevent the development from going ahead, does the covenant secure to them any practical benefits of substantial value or advantage? And that's a question for the tribunal. It's not a review of the decision-making process of the objectors. The tribunal has to make its own assessment of the evidence, as it did in the Reed Coles case, where the court has seen that the tribunal didn't ask whether the objections were genuine, but whether they were justified. And the submission that a local authority shouldn't be treated differently to any other landowner is supported by the Chavaram, Normandy and Basingstoke case at tab 21. This was a case where the applicant tenant held a large office building under a long lease, and the lease said the premises should be used as offices only, and the tenant wanted a modification to permit residential use. The council, which was the landlord, objected. Planning permission wasn't needed because the change of use could be carried out under permitted development rights. The council's position is explained on page 276 in paragraph 5, in the first two sentences there. The council had two objections to the proposed residential use. Firstly, that it would make its reversion less valuable, and the tribunal rejected that on the evidence. Secondly, that the modification would adversely affect the council more broadly, and that's dealt with starting on page 296. And in paragraph 100 in the first sentence, the tribunal says that it's relevant to consider the council both as owner of Normandy House, which was the property in question, and its interest as freehold owner of substantial land holdings in the neighbourhood.
Sorry, which paragraph were you reading from, Mr. Jordan?
Sorry, my lord. Paragraph 100 on page 296.
I have it. Sorry, thank you.
Just the first sentence. And then paragraph 101, the tribunal says that the assessment of benefits must be conducted on a wide-ranging basis, referring to Gilbert and Spohr. And then in paragraph 102, they say the breadth of considerations is not confined to the immediate consequences of the proposed modification, and it will be legitimate in an appropriate case to take into account the possibility that one successful application may improve the prospect of others seeking the release of restrictions applying to other land. That's the ratchet or thin end of the wedge benefit. And then paragraph 103, the Tribunal explains that Mr. Beckett, who was one of the valuers, analysed the benefits in purely commercial terms. And then in paragraph 104, perhaps I can ask the Tribunal to read paragraph 104 and 105. And then on page 299, paragraphs 108 and 109, so the Tribunal said there should be no difference between a local authority and any other landowner. That was the position of the Lands Tribunal for Scotland, and also the our Lands Tribunal, the other tribunal in this case. But in paragraph 109, in the second sentence, the Tribunal said whether there are any such practical benefits will be a question of fact. So not a question of whether the council was genuinely seeking to control its area, but whether there were benefits. And in paragraph 140, on page 305, the Tribunal said, we do not accept the council's case that the retention of Normandy House in office use will make a significant contribution to the economic well-being of the town. They didn't say, is the council genuine? They said, is the council right? That is the correct approach. It's not the right approach to say, well, here's a local authority, we should be slow to interfere. The right approach is, here's a local authority, they shouldn't be treated differently to any other landowner. It's not enough to say they're genuinely attempting to control their environment. We have to decide whether preventing, in this case, residential use of an office building does afford practical benefits of substantial value or advantage, or does not. Can't simply defer to the council on that issue. And in paragraph 143, they explain that they were going to exercise their discretion in favour of making a modification order, although to be fair, the contrary doesn't seem to have been argued. The council itself has always accepted that it acts in different capacities. When it's acting as local authority and as landlord, it says that in its statement of case at paragraph 25.1, even says there may be tensions between its position as landlord and its position as local authority. And in our submission, the Tribunal was wrong to treat the council more tenderly because it was a local authority. The Caledonian case, if it had been decided under Section 84, would no doubt have been decided the same way, because it would have been contrary to the development plan to allow, the equivalent of the development plan, to allow bingo use in the cinema, when that would have disrupted the planning of the area. But that has no parallel here, because the construction of the 2 blocks of flats is provided for in the development plan, and in planning terms, the council is enthusiastically in support of it. The other reason that the tribunal gave for the hypothetical exercise of its discretion was the disrupting negotiations point. The tribunal said it hadn't been provided with details of the negotiations, but that has to be understood with a focus on the word details, because it was provided with evidence of the negotiations from both sides. Can I just show the court what one of the council's witnesses had to say on the subject?
Does it matter, Mr. Jordan? I mean, the question for you here is it appropriate to conclude that you shouldn't exercise the discretion in the way which interferes with the negotiations? Do we care about the extent to which the upper tribunal did or didn't have details? It said it hadn't gone into the granular background.
No, it didn't go into it. I don't dispute that at all. My submission is there was no evidential basis for it to say that by declining to make a modification order, it would avoid disrupting negotiations. There was simply no evidence to support that finding. So I do need to show the court, at least in outline, what the evidence was that was available to the tribunal. If I can go to the supplementary bundle to page 129. Sorry, page 126. If the court could simply read sections 6 and 7 here. This is the witness statement of Mr. Ken Richards, who was one of the witnesses of fact called by the council. He's the principal development surveyor of Manchester City Council. So if the court could read pages 126 through to halfway down 129, please. So that summary of negotiations is all one needs to see, that there was a complete breakdown in negotiations following the issue of the heads of terms on the 13th of January 2022, because the applicant flatly refused to consider the inclusion of forfeiture. And that is indeed what Mr. Rose says in his witness statement as well, and it is correct if one reads the correspondence. One doesn't need to read the correspondence to see that, though. So what happened then was that the applicant applied for consent to carry out the development under the existing lease, and I won't take the court to the letter, but it's in page 199 to 201 of the supplementary bundle. That was on the 27th of May. There was never any substantive response to that letter. The only response was, we're willing to discuss giving you a 250-year lease. That was the council's consistent position. And one of the council's witnesses accepted that in his evidence. That's on page 163 of the supplementary bundle. There's Mr. Norbury, page 163. So, line D, question, but you didn't address the question of consent under the lease. You simply referred to the negotiations, and in your view, the development was unviable. I'd say that's correct, yes. Then the application to the tribunal was made on the 11th of August, about 2.5 months after a request had been made for consent under the existing lease, a consent application which was never responded to except by saying, we're willing to talk to you about giving you a 250-year lease. The council's position appears on page 52 of the supplementary bundle. Sorry, page 53, apologies. This is the respondent's statement of case. 14.2 explains the respondent's position, prepared to provide its consent pursuant to the lease to enable the applicant to carry out the development referred to in the planning application, provided the applicant entered into a new lease, which contained, amongst other things, mechanisms whereby the respondent would be protected in the event that the applicant failed or was unable to complete the said development. And we asked for further information about that, and that was given on page 60. Please provide full particulars of the mechanisms you're seeking, and then they're set out. And they are very much as described by Mr. Richards in his witness statement. The mechanisms are related to an agreement for lease and a new lease. The terms of that new lease are set out. They were to include at paragraph 3, the applicant will be obliged to commence development works within 12 months of the new lease being granted, obliged to complete works within 36 months, subject to force majeure building contract extension, and various other conditions, including box 7, the ability for the lessor to forfeit the lease in the event of the failure by the applicant to comply with the development milestones, subject to reasonable step-in rights of funders, together with a trigger mechanism for a funder to step in to complete the development should there be an event of insolvency. And then it said in B, amongst other things, means that the new lease would contain additional terms, term of the lease of not less than 250 years, capital premium payment, ground rent, and so on. So that was the council's position. There was never any point at which the council was willing to contemplate development under the existing lease. It was only willing to discuss terms for a new lease, and it wasn't willing to give up its right to forfeit if the development milestones weren't achieved. And forfeiture was the major sticking point. And there was absolutely nothing in the evidence that suggested that anything was going to change about that if the tribunal refused to grant the modification order. There was no evidential basis for the tribunal's hypothetical exercise of its discretion on the basis that by dismissing the application it would avoid disrupting the negotiations and ensure that the development would go ahead. On the contrary, granting the application would have increased the prospects of negotiations for a new lease resuming and achieving a successful outcome, because it gave the applicant an alternative, not merely as an attractive alternative, obviously, to develop under a 60-year lease, but nonetheless an alternative. It took away the council's veto power in any negotiations. If both parties have a negotiating position, it's much more likely they're going to reach an agreement than if one party simply has an absolute veto. Making a finding for which there's no evidence is an error of law, as is drawing an inference from primary facts which is not a legitimate inference. That is a proposition we stated in our skeleton argument, which is agreed. So we submit that both the reasons the tribunal gave for its hypothetical exercise of discretion were wrong in law. The next part of my submissions concerns the tribunal's judgment refusing permission to appeal, which is relied on in some respects by the council. As the court knows, normally when a judge in the county court or high court refuses permission to appeal, they fill in a form N460 with a small box where they state their reasons for granting or refusing permission. But here the tribunal delivered a 6-page judgment.
If it helps, it's not going to be part of my oral submission that you're going to be assisted by anything in that part of the reasoning. It's an appeal from the Upper Tribunal's decision, not its decision not to give permission to appeal.
Thank you, Mr. Morshead. Does that help you, Mr. Jordan?
That helps enormously, because I have many criticisms of the things that the tribunal said. That there is one point I think I ought to, 2 points I would like to just make, which I haven't made yet. One is just to show the court the provisions in section 19 of the Landlord and Tenant Act 1927, which may be familiar to the court, I don't know, but which apply to leasehold covenants of the kind that we're concerned with. To have one of the authorities humble. Subsection 1 we needn't concern ourselves with. It's concerned with alienation covenants. Subsection 2 on page 5 is concerned with a covenant, condition or agreement against the making of improvements without a licence or consent. That's been interpreted as meaning any covenant which has the effect of precluding improvements being made, even if it doesn't in terms refer to improvements. And it's also been held that improvements are to be looked at from the tenant's point of view, something which from the tenant's point of view is an improvement. And it says that such a covenant, condition or agreement shall be deemed, notwithstanding any express provision to the contrary, to be subject to a proviso that such licence is not to be unreasonably withheld. But that doesn't preclude conditions being imposed, including payment of a reasonable sum in respect of any damage or diminution and so forth. In subsection 3, in all leases containing a covenant, condition or agreement against the alteration of the user of the demised premises without licence or consent, such covenant, condition or agreement shall, if the alteration does not involve any structural alteration of the premises, be deemed, notwithstanding any provision to the contrary, to be subject to a proviso that no fine or sum of money in the nature of a fine, whether by way of increase of rent or otherwise, shall be payable for or in respect of such licence or consent. But this proviso does not preclude the right of the landlord to require payment of a reasonable sum in respect of any damage. So where there is an alteration which does involve any structural alteration of the premises, then this subsection doesn't apply. And so if a covenant simply says the tenant is not to use the premises other than for commercial use, save with the landlord's consent, there is no implication that the landlord must be reasonable, and the landlord is entitled to refuse consent without being reasonable. And in the present case, there is a covenant in the lease to only use the buildings on the land for commercial uses without the lessor's consent. And the effect of that is that even if we could established that the landlord's consent to erect 2 tower blocks was being unreasonably withheld. It wouldn't get us anywhere because we couldn't use the tower blocks except for commercial purposes without the landlord's consent, which it would be entitled to refuse. So that is why I say that there is simply no recourse, apart from Section 84, to deal with the impasse that the parties had reached in their negotiations. The other...
But why is that relevant?
It's relevant because the tribunal, the result of the tribunal's decision is to leave the parties...
He'd leave you in limbo, you say?
Yeah,
Yeah.
But it leaves the council in limbo as well. I mean, the council wants a development to take place. It doesn't want the warehouses to sit there for the next 60 years.
Yes.
And you want the development to take place.
Yes.
It ought to be possible to come to some negotiated position. Would you say that's not the case?
The parties have tried. There was a mediation. I can't obviously talk about what happened at the mediation, but I can say it didn't succeed. A mediation after the tribunal's decision and before this appeal. It's not that there hasn't been an attempt at negotiation, but the sticking point is forfeiture. Always has been.
But I fail to really understand why. I understand, obviously, the second reason given in relation to the exercise of discretion, if it were to have been exercised. But the fact that there is an impasse has no direct relevance on how the upper tribunal should have conducted this matter at all, save that you would say it should have used its power under 1C to impose its own conditions. Is that fair?
My submission is that it should have held that it had power to make the modification.
Of course.
It should have, neither of the reasons that it gave for declining to use that power were sound reasons. So that took it to...
So you say that, contrary to its assertion, they were in when they said they were in no doubt that the development was capable of being achieved through sensible commercial negotiations, all the evidence showed the contrary.
Yes. There simply was no evidential foundation for that finding.
So therefore, that reason for refusing to exercise discretion if it arose was fallacious.
Yes. Yes, my lord. What the tribunal should have done is issued a decision saying we do have jurisdiction. In relation to the 1C point, I mentioned an email. I said I would show the court that. That is right at the end of the supplementary bundle.
And really, your point is it too simplistic to say it all fell apart on the rock with the forfeiture requirement? Or that, the negotiations, that was a
Yes.
rock and a hard place.
That was the point where the parties, in the negotiation, I'm not talking about the mediation, I'm talking about the negotiations that Mr. Richards described in his witness statement. He said that the applicant was simply refused to consider forfeiture if the building programme wasn't progressed satisfactorily. And that is right, that was the sticking point. And if I just show the court this email and then explain what I submit should have happened. It's the bottom of page 311. It's an email sent on the 15th of May by the tribunal. I just ask the court to read the email on page 312.
I'm afraid I don't have a 311 or 312. My bundle stops at 310.
This was added, I think, quite recently.
Sorry,
Sorry,
I'll pass it to you in a second.
Yeah.
Actually, we can. Let's show.
May I ask if your lordship?
I've got it. I've got it. You want us to look just at the email from the tribunal at the bottom?
And the reply from the council,
Start, yeah, okay. Reverse order.
please.
Thank you.
So the dispute, the essential dispute that the tribunal had to resolve was whether it had jurisdiction, because the council said it didn't and the applicant said it did. And we say the correct result was that the tribunal should have held that it did have jurisdiction, and then it should have invited submissions on whether there should be any conditions, and if so, what they should be. Our position is that there should have been no conditions. The council, no doubt, would at that point have, having realised that it couldn't any longer insist on a 250-year lease, would have finally engaged with the question of what conditions there should be.
What's the point from the emails?
The point of the email is that...
What's the point on which you rely in showing us the email?
The point on which I rely is that the council's attention was drawn to the question of conditions, and the council's response was a question of whether the statutory grounds had been made out as a live one. That was the point the council fought the case on.
Well, that was the question which was asked by the tribunal.
Yes. So the tribunal's focus at the hearing was whether it had jurisdiction, and it held it didn't. And if it had held that it did have jurisdiction, then it would have been required to consider, politically as the next question, whether, not just whether the council's wish for conditions was a genuine one, but whether it was a justified one. And that could have been dealt with either by the tribunal saying, well, the council has had every opportunity to engage in that question and has chosen not to, so we're not going to impose any conditions, which we submit would have been the right response, or to say, we are going to invite the parties to try and agree conditions. If they can't, then we will determine them, as in the Berkeley Square case that the court saw earlier. And that is the same position that this court is now in, if the court allows the appeal.
I hope I may be allowed to make this point on the chronology, in case it isn't clear. That email was sent. I was being told something wrong.
Okay. But the position is the tribunal says, is this all about jurisdiction really, or is it about terms for modification? And it gets a response from the council saying, we're fighting this on the basis of jurisdiction.
Yes, yes, lady.
Well, does it, forgive me, does it say that? Forgive me for cutting across you.
No.
I mean, what the question asked is this case really all about modification?
Yes.
Or is jurisdiction a live issue? To which the reply is, jurisdiction is a live issue.
Yes.
I don't think the council says anything about whether modifications in its reply.
It doesn't respond to that part, no.
Doesn't. Are you saying we should draw an inference from the silence on that?
As part of the overall picture of the council's statement of case and evidence, it was all directed to saying these covenants secure a substantial practical benefit, so the tribunal has no jurisdiction. We're willing to give a 250-year lease. That's what should happen. That was the council's case. The council was asked to consider giving consent under the existing lease, and it never engaged with that at all, either before or during the tribunal proceedings.
So you just say this is another example of the situation between the parties and the fact that it was wrong when considering whether one would exercise discretion to take into account negotiation because the council were intransigent. That's what you're trying to say.
Yes, and also that the council had every opportunity to actually engage with what had been said in the letter of the 27th of May 2022 and in the applicant's statement of case, which was to engage with the development taking place under the existing lease, in response to which it just said, no, our ability to stop that happening is something which means this tribunal has no jurisdiction. And it won. If it hadn't won, and it shouldn't have won in my submission, then the tribunal would have to have considered whether to make a modification order without conditions or with conditions, if it thought conditions might be justified, to have invited submissions on that topic.
Mm-hmm.
No, neither side was suggesting conditions if it got to that stage.
Neither party was putting forward conditions to the tribunal, my lord, no.
But the tribunal could, as in the Berkeley Square case, have said we're going to give a judgment decision holding we do have discretion.
Again, I'm sorry to... This point I'm pretty confident about. My own friend's not quite right about that. In fact, one of our criticisms is that his client did put forward conditions. right at the end of the hearing, without any notice, he said, oh, well, if you're not with me, then impose conditions about, and we can go through them later, I don't want to distract from the learned friend submission, but it's not factually correct to say that, that no consideration was given to conditions.
That is a fair comment. In Mr. Hutchings' closing submissions, at one point he did say, well, there could be a condition, and then there was a brief discussion of it, and then nothing more was said about it. He didn't pursue it. So I think 2 pages in the transcripts, something like that.
Would you accept, I think, that it would have been open to the tribunal itself to have effectively split the trial and said, we're satisfied we've got jurisdiction, we're satisfied that this might be an appropriate case to grant modification, but we think there should be conditions. Go away and see if you can agree them, or if not, come back and argue them. That would have been a proper way forward.
Yes, it's what happened in the Berkeley Square case. It's what happened in the Coles case, where it was a landscaping scheme rather than terms for a new lease. But yes, it's a perfectly proper thing for the tribunal to say is that we have jurisdiction. We want to consider whether conditions ought to be imposed before we exercise that discretion, or conditions ought to be imposed as part of the order we make. And we ask the parties to try and agree it, and if they can't agree it, then we will determine it.
Thank
you. There was one other case I wanted to go to, just to support my submission that the tribunal's function is to determine the dispute and not to defer to the objector, or to say, is the question whether the objector is being genuine. That's the vertical properties case, which is tab 25 of the authorities bundle. The significant point in this case was how the tribunal should deal with a qualified covenant, a covenant which says that the covenantee's consent can't be unreasonably withheld. Does that mean the tribunal has no function? The answer was no. It was a case about a house in Hampstead Garden suburb where the owner wanted to demolish the existing house and build 2 new ones. And that was contrary to 2 covenants, one of which was in a scheme of management under the Leasehold Reform Act 1967, under which the works couldn't be done without the consent of the new Hampstead Garden Suburb Trust Limited, not to be unreasonably withheld. And in his judgment, Judge Reed QC at page 370 he dealt with the significance of the fact that the trust's consent couldn't be unreasonably withheld at paragraphs 103 and 104. Could I ask the court to read those, please? And we submit that is the right approach. Even in a case where the covenant is a qualified one, the question isn't, has the covenantee's consent been reasonably or unreasonably withheld, which requires the question to be asked, could a reasonable person in the covenantee's position have arrived at the decision they did? That isn't the right question. The question is one for the tribunal. It's not a review of the covenantee's decision. It's for the tribunal to say whether, in preventing, in this case, the construction of 2 houses rather than 1, covenant afforded substantial practical benefits. And the answer in that case was no, they didn't, and therefore the application succeeded.
Well, in paragraph 104, the judge is not looking at that question, does it secure practical benefits, but whether it should be modified, which is a slightly different question, isn't it? Have I misread that?
Well, yes, he's discussing the law in general. He begins on page 367 with the heading "the law."
Yes.
And then he sets out various principles that he is applying, one of which at paragraph 95 is that the jurisdiction is discretionary. One is at 99 that compensation won't always follow. Then he deals with the thin end of the wedge argument at paragraph 100. In my submission, when he says it's not material that the trustees were reasonably entitled to withhold their consent, he is applying that to the whole of section 84(1)(a) and not just the discretionary element. But perhaps it doesn't matter because this point goes to the discretionary element.
Yes.
But even if he was focusing exclusively on discretion, nonetheless, in my submission, the point he made is equally good for the question of jurisdiction. There's nothing in section 84 which suggests it should be applied by reviewing the genuineness or even reasonableness of the objector's stance, rather than what the statutory question is an objective one for the tribunal to discern. It is a question of fact. The fact that a reasonable person might take a view that the covenants do secure a substantial practical benefit doesn't matter if the tribunal's own view is that they don't. If we get to the point where the court is persuaded to make a modification order, then the question arises as to the form of that order. To say a brief word about that. The appellant's notice includes the form of order that we suggest the court makes, the clause X. The form of order that was sought in the tribunal was, in my submission, to the same effect but more cumbersomely drafted. That is in the Appendix B to the Council's skeleton argument. They helpfully provide it there, core bundle, page 91.
And X is at page 15, is it?
X is in the core bundle at page 15 to 16, and essentially says, as my Lady Justice Asplin said earlier, it says the covenants are modified to allow the development to proceed in accordance with the conditions in the planning permission. And if one looks at page 91 and see the originally proposed version, essentially it involved applying a proviso to each of the covenants, producing precisely that effect. Perhaps I'll just read the first one on page 91. They're all much the same. But we have no objection to going back to this way of doing it if that is considered preferable. We just thought that clause X was a more straightforward and simple way of achieving the same effect. It wasn't intended to produce any difference of substance, and we don't believe it does.
And this other version, which is attached to the skeleton.
It's page 15 and 16.
No, the second
Oh, sorry.
one, which is at page 91. Was produced.
That's in the respondent's SCOTUS, isn't it?
Yes.
The respondents have
Yeah.
part of the appendix.
They said they didn't like clause X, and they said that wasn't what we proposed for the tribunal. This is what we proposed for the tribunal. We should stick to this, which we will. We're perfectly happy to stick to that, but just thought that clause X was a simpler way of doing it.
And just to be clear, this is what was proposed to the tribunal in closing.
I'm not sure. I think it was in opening. In opening, it was provided. I believe it may have been provided to the council 2 or 3 days before the hearing.
Well, my instructions are that the document was provided at the very end of closing. So I wasn't there, I can't.
We'll check. I'll take
If you
instructions,
would.
if I may, over the short adjournment and give the court an accurate answer rather than speculation.
Thank you very much. Otherwise, Mr. Jordan, is that...
I have attempted to hit the highlights rather than going through everything, so...
Thank you. On that basis, I think we'll resume at 2 p.m, obviously with Mr. Moorehead. And I'd be grateful for a response in relation to that when those were available for the tribunal. Thank you.
All right, people. Please inform forward that the live stream is still running.
I thought Lord Justice Arnold said it should be extended to 2 days when he gave permission for the correspondence.